Hello again. It's me, Mr. Morris, and we're going to continue on the Judicial Branch Study Guide, Unit 6. What we didn't get to last time was parts 2 and 3. I'm going to try and cover them in the next video in the next 10 or 15 minutes. So, you might want to have your study guide out. Might want to have your book. Might want to have this piece of paper with the Supreme Court justices. You might want to have already read these Supreme Court summaries of Plessy versus Ferguson, Brown versus Board, and Griswold versus Connecticut. Starting with 2A. 2A asks you to define original and appellate jurisdiction. I covered this in the video where we discussed Article 3 of the Constitution. Original jurisdiction means the right to hold, or the power to hold a trial. When I say trial, picture what that means in your head, what you've seen on TV and in movies. There's a judge, there's attorneys, there's witnesses, there's a jury. Evidence is presented, witnesses are questioned. That's a trial. Trials happen in courts with original jurisdiction, because original means the case starts there. Appellate jurisdiction is the power to hear an appeal. Now, an appeal comes from a court where the trial was held, and the appeal is to a higher court with appellate jurisdiction. It has the power to review what happened at the trial and make some ruling about whether the trial was fair or not, or whether the law is constitutional or not. Original jurisdiction is the power to hear a case first and hold a trial. Appellate jurisdiction is the power to hear an appeal, which is a request to a higher court to review what happened at the trial. You can't just appeal because you want to insist that you're innocent. You can only appeal if you think there's something wrong with the trial. If the jury was biased or something like that, evidence was inappropriately shown to the jury, or if you believe there's a problem with the law. You think the law is being incorrectly applied or is unconstitutional in the first place or something like that. You can't just appeal because you don't want to go to jail. You have to appeal based on a problem with the trial or a problem with the law. 2B, describe the difference between a federal district court and an appeals or appellate or a circuit court. This is where it would be nice to have either this piece of paper with this on the back, maybe let's see, in your book on page 335. This colorful map would be very helpful. Either way, let's see, I'm going to try and keep that out. On this diagram, the courts at this level have original jurisdiction. That means these courts hold trials. The most common federal original jurisdiction court are the 93 U.S. district courts. They're scattered all over the country, taking cases from various regions within the country. There's 93 of them, and they're called U.S. District Court. If you ever break a federal law, you will have your trial at one of the 93 U.S. federal district courts. Now, there's other courts with the same kind of jurisdiction: territorial courts, D.C. courts, tax courts, and so on across. You don't really have to know all of them. But those are courts set up with more specific jurisdiction than just district courts. So if you don't pay your taxes, you'll have a trial, I guess, at some point in a U.S. tax court. If you commit a crime in one of our territories, you will be in a territorial court. If you're a part of a business that carries out trade with other countries and something goes wrong, maybe you might end up in a case in the territorial Court of International Trade. I'm sorry. If you ever sue the government, that's U.S. Claims Court. But they don't handle very many cases. Most federal cases are handled in one of the 93 district courts. Now, where are these district courts? Well, that'd be where it'd be nice to have this piece of paper or the colorful one in your book. If you look closely at this piece of paper, I know some regions are shaded and stuff. We'll get into that in a minute. But if you were to look inside one of the larger states, for example, look at Texas, you will notice that there's very faint lines kind of within Texas, and the Texas itself is divided up into 1, 2, 3, either 4 or 5 districts. Those are district courts. Those are the district court jurisdictions within the state of Texas. States that don't have the little lines in them, that means the whole state is a federal district. And there's one federal district court for all the federal crimes that happen in that state. Now notice these are not state courts, totally different from state court systems. If you break a state law in Texas, you'll fall under the Texas state court system, and I don't have a diagram of that because we're not supposed to learn that. But if you break a federal law in Texas, it matters where you do it, because then you'll be in either the northern district of Texas or the southern district of Texas or whatever. That's the U.S. district court where your trial will be held. And if you look through this whole map, and you'll notice California has a bunch of districts, and some of the more populated eastern states have a lot of districts. Add up all the districts, there's 93 of them. 93 district courts. Now, what are these shaded regions all about? Well, back on this side, in addition to all these courts with original jurisdiction, there are 13 courts with appellate jurisdiction. We call them appeals courts or appellate courts or circuit courts. They all mean the same thing. I'm sorry about the multiple words, but they all mean the same thing. That means there are 13 courts that can hear appeals from the original jurisdiction courts where the trials are held. Now, where are these 13? Well, alright, the country is divided up into 11 regions. They're shaded for you. And then there's 2 appeals courts in the DC area that handle special kinds of cases. So there's 11 regions plus 2 appeals, and each region has its own appeals court, or appellate court, or circuit court. They all say the same thing. And then there's 2 that are based in DC that handle certain kinds of cases. So the appeals courts only hear appeals from the district courts that are in that region. So the 9th Court of Appeals only hears appeals from the trials that are held in this region, and that includes Hawaii and Alaska. In the 10th Circuit, the 10th Circuit Court or Appeals Court only handles appeals that come from the trials, in this white area out west: Colorado, New Mexico, Utah, Wyoming, Kansas, and Oklahoma, and so on. So there's, if you look across the whole country, there are 11 regions or appeals regions where cases, and each region has one appeals court that hears the appeals from the trial courts, the courts with the original jurisdiction in those areas. So that's the difference between a appeals court and that's the difference between appeals courts and district courts, courts with appellate jurisdiction, and courts with original jurisdiction. Now, at the top of the court system, of course, is the Supreme Court. It has, if you remember from the first video on the judicial branch, it has both kinds of jurisdiction. It is possible for a trial to actually be held at the Supreme Court under its original jurisdiction authority. That's very rare. Typically these days, the only kind of cases that start and end at the Supreme Court are cases when 2 states sue each other, which happens occasionally, but not very often. The vast majority of the Supreme Court's cases come to it by it being appealed from the district court level up to the appeals court level, and then up to the Supreme Court level. We'll handle that in the next a couple of videos from now. So, oh, and you might want to point this out. This is kind of interesting, especially what's going on right now with the Senate refusing to consider Obama's nomination to the Supreme Court. It's already starting to happen. What's interesting here is, so, let's say there's a case involving abortion or gay rights or affirmative action or one of the controversial issues. Let's say a case arises in Region 9. The trial is held, whoever loses appeals. So they appeal, let's say, from a California court to the appeals court that handles those appeals, the Ninth Court of Appeals. Then appeals are heard only by judges. There's no jury, there's no witnesses anymore. They only review what happens in the case, the facts, etc. So then let's say the panel of judges on the circuit court, they decide in favor of, let's say, I don't know, against whatever the issue, whatever the case was. They say that something is unconstitutional. Well, what if the same exact kind of case comes up somewhere else in the country? Let's say Region 8. What if the same kind of case, the same issue, something about abortion or something about affirmative action, something comes up in a totally different region? Well, the trial would be held at one of those district courts. Whoever loses would appeal, and that appeal would be heard by the circuit court for that region, the 8th Court of Appeals. Well, what if the 8th Court of Appeals decides a case about the same issue, the opposite of how the 9th Court of Appeals decided a case on the same issue? What if in this region, the circuit court said that a certain abortion law was unconstitutional, and what if the same kind of law that was passed, and maybe in a different state, is found to be constitutional by a different appeals courts? Well, now what you have is basically a situation that the Supreme Court normally hates, because something is illegal in this part of the country and something is legal in this part of the country. The Supreme Court doesn't like that situation and will almost always take, those will be appealed obviously because no one likes losing, those will be appealed to the Supreme Court. Usually the Supreme Court will take those cases because they don't like a situation where federal law or the Constitution is being interpreted differently in different parts of the country. So that's a major reason why the Supreme Court takes a lot of its cases, to make sure that the cases, the law and the Constitution are understood the same way across the whole country. What we have right now is a situation where there's 8 members of the Supreme Court. We're waiting on the 9th, but that might not happen soon. So in the time being, there's 8 members of the Supreme Court, 4 conservatives, 4 liberals, and on certain issues there's just going to be a tie. And when there's a tie, what it means is that nobody wins or loses at the Supreme Court level. It's whatever the decision was back at the circuit court. And that could create a situation, depending on the details, that could create a situation where you have one federal law that's interpreted differently in different places in the country, or one part of the Constitution that's interpreted differently in different parts of the country. And so something is legal here and illegal somewhere else. The Supreme Court doesn't like that, but right now, with the 4-4 thing going on, there's the possibility of that happening and staying that way for months or maybe even a year or more. Anyway, that's district and appellate courts, original and appellate jurisdiction. That is number 2A and 2B on your study guides. I'm going to cut this off. We're at 14 minutes, so see you in the next video.